They're all only now about those states. What about the other 47 states and the people born in those states under the 14th Amendment? No, the Supreme Court says, well, we're not here on the merits of the 14th Amendment. Only the parties that are in front of that judge. You know, we have 3 different nationwide injunctions that just got struck down or stopped about birthright citizenship. We got Maryland, we got Massachusetts, we got California. The judge and it cannot. We are now going to take back the power to declare things in due course with a right order of operation, as Kavanaugh said, about a case.
The Supreme Court just dropped a bombshell. Federal judges can no longer issue nationwide injunctions. Translation, executive power just got a whole lot scarier. Stick around to find out how this decision could leave millions helpless while letting the executive branch play by its own rules. Before we move on, I'd like to ask you a small favor. If you appreciate this content, please take a second to like this video and subscribe to the channel. Over 98% of you watch the videos without subscribing. It costs you nothing, but it makes a huge difference to us. So, did you click the subscribe button? Great. Thank you so much. Now, back to the video. Imagine playing a basketball game where only one referee miles away in a separate building can blow the whistle for fouls. Chaos, right? Fouls don't get called when they happen, and by the time that lone referee gets involved, the game's already over. Well, that's pretty much what just happened with the Supreme Court's latest ruling. For nearly a century, federal courts have served as that on-the-ground referee, issuing nationwide injunctions when government actions break constitutional rules. This allowed judges to hit pause on sweeping unconstitutional policies while challenges worked their way through the legal system. But now, that authority has been gutted. The decision, spearheaded by Justice Amy Coney Barrett, means that only the Supreme Court itself can now issue rulings with nationwide impact. That's right, those lower court judges who could once stop a harmful policy in its tracks.
We got a bombshell of a Supreme Court decision. Have a seat for this one, everybody. The United States Supreme Court 6-3 MAGA majority has just ruled for the first time in American history. Now it's going to have to be done through individual class action cases and/or individual lawsuits in all 50 states about something so fundamental. The district court level, the first line of defense to protect our Constitution, no longer have the power to issue nationwide or what's called universal injunctions to block abuses of executive power.
Their hands are tied. Critics are calling this one of the most dangerous constitutional rulings in recent memory, and they might be onto something. Without federal courts acting as impartial checks, executive power just got a whole lot bolder, and not in a good way. This shift is especially alarming because the Supreme Court is notably selective about the cases it hears. If a harmful policy falls into the mix, what are the odds they'll step in quickly? The case at the center of this ruling is Trump vs. CASA Incorporated. At its core, this was a legal fight over executive overreach. More specifically, it involved an executive order from the Trump administration targeting birthright citizenship, a move many experts labeled unconstitutional from the get-go. The order attempted to strip certain children born in the US of their citizenship, bypassing legislative processes entirely. That's right, a pen stroke to change the entire meaning of the 14th Amendment. Civil rights groups sprang into action, filing lawsuits across the country to block the order before it could upend lives. And initially, district courts stepped in, issuing nationwide injunctions to stop the chaos.
About 100 years of precedent allowing federal courts at the district court level and at the Court of Appeals level to issue injunctions that stop an abuse of power by the executive branch. No, says the supermajority. The United States Supreme Court didn't just rule that the 14th Amendment can be changed by executive order like Donald Trump wants. But it did just totally turn upside down and reverse. You can't ever use it because it's not part of the history of America, and the only court that's allowed to make effectively a nationwide declaration about whether the executive branch is out of control or not is the United States Supreme Court.
But not anymore. In its reasoning, the Supreme Court made it clear the authority of district courts only extends locally. Nationwide impact, that's reserved for them and them alone. This might sound neat and tidy, but imagine the implications. Let's say an administration rolls out an executive executive order today that openly violates constitutional rights. Without federal courts issuing immediate injunctions, those policies stay in effect until the Supreme Court weighs in, and that can take months or even years. Picture it like this. Your house is on fire. You call 911, but when the firefighters show up, they inform you they aren't allowed to use the hose until their boss at the station personally gives them the green light. By the time that approval comes through, well, good luck finding anything left to salvage.
And then you have to have a ruling about it. That's one. Or two, you've got to move quickly off of a preliminary injunction, get it up on an emergency basis to a willing appellate court, get it up on an emergency basis to a willing United States Supreme Court. Meaning we only got two ways now to rein in an abuse of power, lawless, or as Amy Coney, as Ketanji Brown Jackson says in her dissent, I'll read from, a law-free zone of Donald Trump, to make a declaration about the substance of the matter, the merits of the case. So as of right now, let me just summarize it this way as I continue this hot take. I'm Michael Popok on the Midas Touch Network.
The same concern applies here. Without lower courts acting as firefighters to stop unconstitutional damage immediately, harm will spread unchecked. Legal expert Michael Popok argued that this ruling essentially lets the executive branch operate without meaningful immediate oversight. It's like dismantling the smoke alarms, he said, pointing out that the decision cripples one of the judiciary's most critical tools for maintaining checks and balances. And let's face it, a lot of what happens in Washington feels abstract, far removed from how the average person lives day to day. But here's why this ruling matters beyond legal theory. Nationwide injunctions were never just courtroom theatrics, they were lifelines. Think back to Trump's travel ban targeting predominantly Muslim countries. Lower court judges issued injunctions to block it, halting the policy before thousands of travelers and families were torn apart. Those cases later reached the Supreme Court, but at least during the process, lives weren't upended. The ruling removes that safety net, and that's where things get dangerous. For the everyday American, this decision raises a chilling question. Who's going to protect constitutional rights when policies take immediate effect? Without intervention, those impacted would have no choice but to file lawsuits in multiple states, a costly and lengthy process that most people can't afford. This doesn't just disadvantage individuals, it creates a system that favors the powerful and connected over everyone else.
Narrow their injunction from a nationwide injunction to a narrow injunction only involving that state particularly. What it means for right now is that those three judges that have blocked the executive order of Donald Trump on birthright citizenship, then those lawyers have to move quickly, and they will. Like the ACLU, Democracy Now, the Democracy Forward, move quickly to get to the appellate court quickly.
People who already have the resources to play this legal game get to keep playing, while everyone else gets sidelined. Justice Barrett and the majority justified their decision by arguing it preserves judicial integrity, ensuring rulings aren't over-applied. But critics say it does the opposite, effectively giving the executive branch a blank check. Writing for the dissent, Justice Sotomayor warned that unchecked executive actions could cause irreparable harm to those affected. Her concerns weren't just hypothetical. We've seen this play out before. Policies that violate rights can ripple across communities, leaving devastation before they're even questioned in court. Now, here's the kicker. Every time the Supreme Court exercises its self-proclaimed exclusivity, it risks becoming a bottleneck. They're already notoriously slow, with thousands of cases petitioned each year and only a fraction taken up. Adding to their monopoly only increases the backlog. It's like asking one DMV employee to process everyone's driver's license in the entire country. Sure, it keeps things centralized, but at what cost? Justice delayed becomes justice denied. And for marginalized communities, for anyone living paycheck to paycheck, even temporary harm can be life-altering. So what's the immediate fallout? For starters, it's now harder than ever to hold governmental overreach in check. If the executive branch rolls out a problematic policy, opponents can no longer rely on federal judges to provide a temporary pause. That means suffering may continue unchecked until the Supreme Court decides if it's worth their time. This isn't just a shift in how power is distributed. It's a dismantling of safeguards that have protected people from unconstitutional actions for decades. decades. Next, we're diving into the human cost of this ruling, who's left defenseless, and why some groups are far more at risk than others. Because spoiler alert, this isn't just a problem for legal experts and politicians. It's a problem for everyone the system was supposed to protect but doesn't. If you think this ruling is just some arcane legal battle that only lawyers and politicians care about, think again. This decision doesn't just affect courtroom strategy, it's a full-on gut punch to the most vulnerable people in society. Justice Ketanji Brown Jackson said it best in her dissent. This ruling creates a law-free zone, a space where the executive branch can flex its power without fear of being challenged, especially by those who need protection the most. Let's break it down. Jackson warned that this zone doesn't really mean no law. It just means law for some, but not for others. If you're poor, uneducated, or part of a marginalized community, you're left exposed. Why? Because this ruling shifts the burden of stopping wrongful executive actions directly onto individuals. And let me just say, most people don't exactly have the time or money to fight an expensive, drawn-out legal battle across multiple courts. The executive branch can wreak havoc, and by the time the wheels of justice start turning, it's usually too late. Picture this: a single mother in a red state town wakes up to a new executive order slashing benefits she depends on to feed her kids. She knows it's unconstitutional, but what's she supposed to do? Hire a lawyer and sue the government herself? Her options would be to coordinate statewide lawsuits or wait for a class action that could take years. Her plate's already full trying to survive the week. Meanwhile, the government isn't waiting around. The policy is already affecting people like her before a court has even had a chance to ask if it's legal. Now let's throw even more legal jargon in the mix. Thanks to this ruling, challenging a single policy could require lawsuits in every state where it's enforced. Justice Sonia Sotomayor called this out, describing it as another crack in the foundation of the rule of law. She wasn't being dramatic. Before this decision, one federal injunction could stop the policy nationwide while courts sorted out its constitutionality. Now, a scattershot strategy of lawsuits and appeals creates barriers that are costly, messy, and wildly inefficient. Even the dissenting justices agree this isn't what justice is supposed to look like. Here's where things get scary. Justice Jackson pointed out that this ruling will hit the most disadvantaged groups the hardest. Think people who lack education, money, and access to legal aid. These are the folks less likely to know their rights, let alone have the resources to defend them when they're violated. Jackson warned that these individuals will be left beholden to the executive's whims. Let's call it what it is: people with power and privilege. They'll find loopholes in lawyers, but the powerless, they'll be left staring at an iron door with no key. Even worse, this decision could discourage people from challenging the government at all. Imagine knowing that even if you protest an executive action in your state, it still might go into full effect everywhere else. It's daunting. Add the financial and emotional cost of taking legal action, and you've essentially built a giant brick wall between the executive branch and the people it's supposed to serve, not protect from lawsuits. It's no wonder Jackson called this scenario dangerous. The thin veil of accountability just got thinner. And here's the kicker: Justice Sotomayor ripped into what she called the constitutional gamesmanship being played. She accused the government of acting selectively, enforcing unconstitutional orders on everyone except the people who bring lawsuits. Why would they do this? To avoid broader legal challenges that could shut their policies down entirely. It's a sneaky strategy, but it's not fooling anyone. Sounds good in theory, right? The problem is, this process assumes higher courts are itching to jump in. Spoiler, they're not. Direct appeals might speed things up a bit, but they still land in the lap of, you guessed it, the Supreme Court. Considering this ruling came from the same court, don't expect them to open their doors and roll out the red carpet for every emergency appeal that hits their desk. Ultimately, they pick and choose what they hear, which raises the question, will they even bother with cases targeting executive misconduct? It's like asking a referee to review their own calls after already making the call. If you think this all sounds exhausting, you're right. These methods are expensive, convoluted, and most importantly, slow. Justice Sotomayor didn't sugarcoat that reality. She made it clear that for the average person, especially for those who are struggling just to get by, these legal hoops are basically inaccessible. Poor, single parent, overworked, low on savings. Sorry, the courts are now a pay-to-play system, and shortcuts like class actions and direct appeals still require resources most people don't even dream about. Marginalized marginalized groups get hemmed into narrower corners, while those in power, helped by teams of legal experts and millions in backing, get to play the long game. It's classic justice for some. Let's go back to the birthright citizenship order for a second. Already lawyers are scrambling, some are chasing class actions, others are hoping to fast-track appeals that could block the order before it's enforced. But here's the hard truth, even if they win temporarily at lower levels, nothing sticks until the case reaches the Supreme Court. That's the new bottleneck. Lower courts are still issuing decisions, sure, but without the ability to enforce injunctions nationwide, it's like shouting into the void. By the time the Supreme Court reviews the dispute, this unconstitutional policy might have already upended countless lives. It's a perfect storm. Urgency collides with an institution notorious for dragging its feet. The real victims, the people these policies target. And so we're left with this uneasy thought: has this ruling pushed us into a point of no return? The dissenting justices did provide tools for resistance, but this fight feels lopsided. Class actions and direct appeals might chip away at executive overreach, but does that really restore balance to the system? Think about it. If lawsuits take years to resolve and relief only comes when the harm is long done, is that even justice anymore? Or is it just paperwork? Still, one thing's clear: persistence matters. Advocates, attorneys, and communities can't afford to sit this one out. Their work may be slow and painfully uphill, but without it, those breadcrumbs of resistance left by Jackson and Sotomayor will vanish. And if that happens, what you're left with is a government unchecked, policies that can spread harm freely, and a court ruling that made it all possible. Oddly enough, that might be this ruling's one silver lining. It's forcing people to get creative, to push back harder. Next, let's talk about what all this means for the bigger picture, because this isn't just about one decision or one policy. It's about what kind of justice system we all live under. Is it one with tools that actually work, or just a bunch of levers that no longer connect to anything? This ruling doesn't just change how courts operate, it changes who gets access to justice altogether. When fighting unconstitutional actions turns into a marathon of lawsuits and legal fees, justice stops being a right and starts being a privilege. And let's be real, who does that privilege benefit? Not the people scraping by, that's for sure. Now more than ever, staying informed matters. Support groups fighting for constitutional rights, call out leaders when they overstep, and don't look the other way when systems start favoring power over fairness. Because if the courts won't protect us, who will? No, seriously, who?